Good day, Crime Talk aficionados. We have a great show for you today. First, the Delphi murder trial. Did the prosecution open the door to the odinist theory? Prosecutors didn't get the bang that they were looking for in some testimony yesterday. Lori Vallow's trial is delayed in Arizona. That's right, another competency evaluation. Bryan Kohberger gets another hired gun. Sarah Boone testifies, and she didn't help herself, in my opinion. The Georgia high school shooter pleads not guilty. Will the Menendez brothers learn their fate this week? Are they going home or are they going to remain in prison? Another Mother of the Year contestant, and wait until you hear this story. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And remember, you can check us out on any of your favorite podcasting apps as well. Now, before we get to the docket, that's right, go to crimetalksearch.com, sign up for that background subscription service today. When you do that, you're going to be able to do as many background searches on anyone here in the United States that your heart desires. All right? If somebody new is coming into your life, you want to check them out. When you do a search, when you do a background search, like we have shown you, we've done it. We do it on people that are involved in cases. You're going to get some address history, possible relatives, neighbors, jobs, education, usernames, social media, assets that are owned, criminal history, bankruptcies, judgments and liens, everything that you want to know about the person that's coming into your life. Check them out. If you're dating somebody or gonna be dating somebody, it is dating malpractice not to go to crimetalksearch.com and check them out. And remember, you can cancel that subscription at any time. Whenever you've done all the searches you want to do, you can stop. All right, let's go ahead and get to the docket today, and let's open the record for October 23rd, 2024. First, that's right, the Delphi case. Well, lawyers for Richard Allen are once again asking the court to allow them to discuss their odinist theory in the Delphi murder trial. Now, if you don't know about this case, Richard Allen is charged with the murders of Libby German and Abby Williams back in February of 2017. Now, the defense says that where the crime scene was located and where the girls were found contains evidence of ritualistic murders tied to this Odinism, pagan Norse religion, and is also associated with some white nationalist groups. Now, according to the defense motion, Mr. Allen has a Sixth Amendment right to offer the jury an alternative to the prosecution's theory. And in this particular case, yes, the defense does have a right to present a defense. And as we saw yesterday in the Sarah Boone trial, which we'll talk about in just a little bit, the judge says, fine, I'll let you present your evidence. Why? Because it takes away a legal theory. So the judge, being cautious and trying to protect the record, would say, fine, I'll let you introduce some of this odinistic theory, but we're not going to go so far down the road, but I'm going to let you present your defense. And guess what? If the jury rejects it, it has been rejected. Not an appellate issue where you're going to have to retry the case. So, like I said, the prosecution, are they the ones that opened the door to this odinist theory? Well, the defense believes so based upon the questions and answers from the crime scene analysts who testified for the prosecution. The analyst was able to describe how various leaves and branches were placed on the girls' bodies, and they seemed to be laid out in a particular way with some sort of meaning to it. Guess what? Kind of opening the door to the odinist theory. Prosecution did it. That's one of the things you really have to worry about in trial, ladies and gentlemen. If you're told to keep something out and you win, like prosecution did, don't do something that's going to open the door. They should have just shown the photographs and left it there. Now, the defense gets to do, obviously, cross-examination, and they can get this theory in without actually letting it in. They can maybe save it for closing arguments based upon the sticks and the placement of all the bodies. So we'll see. Because, like I said, their theory is that the sticks of the girls appear to be arranged in a pattern or an arrangement using a person's own eyeballs, common sense, logic, and reason could cause a reasonable person to believe that the sticks were formed in some pattern, arrangement, and weren't being used to conceal the bodies. That's according to the defense motion. Now, the defense argues that not providing the jury with this alternative theory would leave the jury with the only explanation of the state. And they also argue that it could be confusing for a juror who might believe the arrangements of sticks was intentional. Now, the defense is also asking to use the findings from a Dr. Perlmutter, an expert on ritualistic murders, who supports their odenistic theory that has previously been shut down. Now, jurors in the trial of the Delphi murder case have been given their first glimpse of the bridge of the bridge guy as prosecutors played the video recorded on Libby German's cell phone, capturing the last moments where Libby and her best friend Abigail were alive. Now, the footage, which is approximately 41 seconds long, has Libby, who reached the end of the Monon High Bridge ahead of her friend, turns to film Abby as she picks her way carefully through the structure's rotten timbers and gaps. Now, caught in the frame several feet behind the teen is a man dressed in a blue jacket, jeans, and a hat. His hands are in his pocket, his chin is tucked down so that his face isn't visible beneath that hat, and he is little more than a blur that is moving behind the girls. Now, as Abby reaches the end, Libby's cell phone, the lens, then focuses on the gravel near the girl's feet. She appears to cast about, taking in the steep slope to their left and the track which simply disappears before them. Now, one of the girls can be heard saying, there's no path, so we have to go down here. See, the trail ends here, you can hear voices saying. Now, as the prosecutors pointed out in their opening statement, once the girls were across the bridge, there was no escape. Moments later, a male voice can be heard uttering the now infamous words, "Guys, down the hill," and one of the girls lets out a yelp as if she's startled. But if the state had hoped to definitively identify Richard Allen as bridge guy by the footage with a series of eyewitnesses, their efforts, didn't exactly hit it out of the park yesterday. So 3 separate eyewitnesses confidently stated that they saw bridge guy and identified him from a screenshot on the video. But the descriptions each gave the man that they saw was not only wildly different from the video image, it was wildly different from the defendant. So Rayleigh Voorhees, who was 16 at the time, described seeing a man dressed in black boots, black shirt, black jeans, black jacket, with a black hoodie pulled up over his hat and a black mask pulled up over his mouth and nose. She described him as unfriendly and said that he made her feel unsettled as their paths crossed on the bridge there on February 13th. Now, when she and her sister friends took a trip to the Monon High Bridge trail to take pictures on that particular day, she remembered the man as being muscular, about 5'10", and in his 20s or 30s, and conceded that her memory may have been altered by seeing the subsequent picture of the bridge guy. Breanne Wilbur was the next witness. She was with Voorhees that day, and she too described seeing a young, youthful, muscular, tall man dressed in black. Before saying the moment she saw the picture of bridge guy, she knew that that was the person who she had seen. Now, Betsy Blair gave a description of seeing a man standing out on the Monon High Bridge. She was out for her regular fitness walk along the trails when she saw him and said what appeared to be waiting or looking for someone. She said, "I just felt like he wasn't looking for me." Yet the man that Ms. Blair described was also youthful, with fluffy brown hair and in his 20s or 30s, slightly gaunt, and with closely cropped hair and barely 5 feet tall. Now, Allen is 52 years old, and obviously the attorneys brought out the differences in the descriptions as well as to what he looks like. Now, also earlier in the day, the defense grilled the crime scene analyst who took the stand to complete the testimony which he had started on Monday. Now, under a pretty aggressive cross-examination, the analyst was forced to concede that despite taking numerous swabs and samples from the crime scene and even each victim, they found no DNA evidence in the crime scene or the bodies that matched Mr. Allen. Gonna get interesting. Let them try the Odinist theory. I say let them try it. They still have a lot of hurdles to overcome in this case, And don't get me wrong, we give him the presumption of innocence. I'm a defense attorney. I get it. These guys are doing their best. We'll see what weight or credibility comes out as it relates to these alleged confessions, false confessions. If you're, for the defense side, we're going to have to wait and see. It's getting good. Man, I wish this case was televised. Next, the Lori Vallow trial has been delayed again. Why? Well, Vallow's defense lawyer filed a motion for what is known as a Rule 11 evaluation. That's called competency, ladies and gentlemen. So on October 21st, Vallow's motion was granted by the judge. And under the Rule 11, the Forensic Service Divisions will evaluate Ms. Vallow for competency as it relates to stand trial in her criminal cases. Now, the judge is the one who ultimately ordered the evaluation. Now, 2 qualified mental health experts will be appointed to examine and evaluate Ms. Vallow. Her February trial is now vacated because everything tolls when competency is at issue. Now, as you may recall, Vallow's trial in Idaho was paused for some 10 months while she was restored to competency to stand trial. Now, in Arizona, both the prosecutors and the defense are ordered to provide medical and criminal history to the Maricopa County's Correctional Health Services Division, and 2 qualified mental health experts will be appointed to examine Ms. Vallow and determine if she is competent to stand trial. Now, really, normally to stand trial, you simply have to know the role of all the parties. What does the judge do? What's the goal of the prosecutor, the defense? Do you understand the charges against you? Do you understand kind of the legal process? Very rudimentary when it comes to the legal system. But you also then have to be able to assist your attorney in the defense. I had a client once that seemed normal. We would talk and you'd spend an hour, 2 hours with him, and you would just think, that's 2 hours of my life I'll never get back. Ultimately, we comped him because we just couldn't ever talk about the case. He was found not to be competent, and after a certain period of time, with so many evaluations and the chances of him being restored to competency were so few, they dismissed the case. I don't think they'll do that in a homicide case, but just give you an example, that's a possibility. And like I said, as you may recall, in Lori Vallow's Idaho sentencing, she was diagnosed with a personality disorder and hyper-religiosity after she told the court that no one was even murdered in those cases. Oh, and that she talks to Jesus. So if she is found not to be competent, what is going to take place? They're going to have to try to restore her, usually through medications. But if she doesn't want to take the medications because it makes her feel tired, makes her feel funny, they, being the state hospital, then can ask for the medication to be forcefully given to Ms. Vallow. Needless to say, this case is going to drag on forever. Now, we did bring up last night on our live show. I want to thank everybody for taking the time to check us out yesterday. And really what it amounts to is her appeal in the Idaho case is due tomorrow. So the appeal in Lori Vallow's Idaho case is due tomorrow. I haven't seen any notices or requests for another extension, as they've already received 3 to file their brief. I would imagine maybe Arizona would lose a little interest in this case if the death sentence or if the life sentence in Idaho is upheld. Ms. Vallow is accused of conspiring in regards to the shooting of her 4th husband, Charles Vallow, and plotting the attempted murder of her ex-niece's husband, a guy by the name of Brandon Boudreau. Now, in the case of Charles Vallow murders, Lori's late brother, Alex Cox, argued self-defense to the police, but the police in Gilbert believes that Cox was also the shooter in the Boudreau case. Now, Cox died back in December of 2019. And here, initially, the trial was scheduled to begin in August, but a judge later decided to push the trial to February. And despite Lori Vallow not wanting to waive her speedy trial rights, the judge set the matter much farther out, which has now been stayed as well. Now, as you also may recall, Lori Vallow was extradited to Arizona back in November of 2023 after being sentenced to life in prison without the possibility for parole for killing her 2 youngest children, Joshua J.J. Vallow and Tylee Ryan. Oh, and by the way, she was also convicted of conspiring to kill Tammy Daybell, who was Chad Daybell's former wife. and Chad Daybell is her current husband number 5. The lady is a black widow. So we'll see how long that's going to take to get her back to being competent. Bryan Kohberger hires another expert. I'm telling you, ladies and gentlemen, the defense in the Bryan Kohberger case, this is a casebook example of litigating a quadruple homicide, a death penalty case. They are pulling out all the stops, and they are making the government work textbook. Now, you may not like it. I get it. But the reality of it is, this is what is supposed to take place. You get kind of super due process when you are charged with capital offenses and the state wants to impose the death penalty. They really can't be denied any of their expert requests. And guess what? They're pulling out all the stops. So Bryan Kohberger, obviously accused of quadruple homicide. His team has hired a forensic pathologist who worked in the O.J. Simpson case and apparently is going to testify for the defense at a motions hearing on November 7th. Now, obviously, Bryan Kohberger is accused of the quadruple murders of killing Ethan Chapin, Zaina Kernodle, Madison Mogan, and Kylie Gonzalez at their campus house there in Moscow, Idaho, back in November of 2023. So his defense team have brought on forensic expert Dr. Barbara C. Wolf to testify remotely at the hearing on November 7th. Now, Wolf is currently the medical examiner of Florida's 5th and 24th districts. And like I said, she worked on the O.J. Simpson's defense team while he was on trial for the murder of Nicole Brown and Ronald Simpson back in 1995. Now, at that time, Wolf worked as the director of the anatomic pathology at the Albany Medical College and examined at least one of the infamous now gloves. You know, if the gloves don't fit, you must acquit. Anyway, it's unclear exactly what she's going to testify to in this particular case, but it's going to be on November 7th. That's going to be an interesting hearing, and we are going to bring it to you live. So make sure you come to Crime Talk and check it out. Now, obviously, the allegations in the case against Mr. Kohberger are that DNA evidence was found on a K-bar knife and sheath found at the victim's off-campus home, though no murder weapon has ever been found. Police say that the cell phone data and surveillance puts Mr. Kohberger's car near the crime scene, though the defense disputes those allegations. The defense claims that Kohberger was miles and miles away off campus when the students were murdered, and his official alibi, they claim that Mr. Kohberger was driving alone on the night of the murders to look at the moon and the stars. Who knows? Maybe he was. But remember, DNA on the K-bar sheath, no knife, but I'm telling you, and that's right, ladies and gentlemen, why would you go anywhere else? What other channel has a K-bar that they can say the host has had it since 1988 when he went to Marine Corps boot camp? That's why you come here, ladies and gentlemen. You can see it. This is hard. Ugh. They got some explaining to do. Okay? Got some explaining to do how his DNA got there. It's going to be interesting. I look forward to it. It's going to be a great trial. Next, Sarah Boone testifies. That's right, Sarah Boone facing charges of second-degree murder over the death of her boyfriend, Jorge Torres, who died of asphyxiation back in 2020. That's right. 4 years, ladies and gentlemen. 4 years, 8 attorneys later, Miss Boone finally took a stand on Tuesday during her trial, and she recalled how the two, she and Mr. Torres, had been started a game of hide and seek, because that's normal. But apparently, if you describe it as Miss Boone does, all you do is sit around and drink vodka and get drunk. And so you get two drunk people playing silly games. Anyway, somehow he winds up getting into the suitcase. And she said, well, he tapped me on the knee and said, "You're it." She then apparently ran upstairs, just waited on him to find her. And then she went downstairs and find where he was. Anyway, she looked over and saw he was settling into the suitcase. So she zipped him up. She thought it was funny, and they were joking that he was small enough to actually fit inside the suitcase. Now, Ms. Boone continued in her testimony. From there, we were laughing about it, and it was just strange that he was so small to fit into that little suitcase. And then it moved around a little bit, and he was still in the suitcase. She still thought it was funny, and he's still in the suitcase, and she was thinking he and I couldn't believe that he could fit. Anyway, Miss Boone, who has claimed that Mr. Torres had been abusive to her, said that the case fell over and she started videotaping it. That's interesting, isn't it? So she told the court and the jury that she wanted to use the opportunity to talk to Mr. Torres as he was not able to get out. Very captive audience, I guess. Anyway, the video footage from the phone shows him thrashing around inside the suitcase, telling her that he can't effing breathe as she yells back at him. Well, she took 2 clips of her laughing at Torres as he begged for his life, and she can be heard saying something to the effect of, "For everything you've done to me, F you, stupid." Well, also telling the jury, she continued, his hands started to come through, and so I shook the suitcase to try and get his hands to go back in, telling him, please stop doing this to me, because I guess she was in fear. Anyway, when questioned further, Miss Boone said that her boyfriend had been forcefully trying to escape and that he was angry at her. I'm sure he was probably getting a little angry because he thought he was going to die. Anyway, she then said that she was always in fear, adding, he used to tell me he would make me unrecognizable or I would lose my life. She also stated on the stand that she then grabbed a baseball bat to poke his hand to go back into the suitcase, and she hit his hand with the bat. She said, I started with his hand and he was still trying to get out, so I started pushing on the suitcase, hoping that his hand would go back inside. Finally, he basically stopped and retracted his hand, adding that her split-second decision prevented him from getting out and attacking her. There was no more of him trying to break through the suitcase, so I felt safe enough to turn it back over. She also went on to say that she later went upstairs and fell asleep, waking up the next day to figure he was downstairs drinking or looking for jobs. But after unzipping the suitcase, she said that I don't think I've ever experienced anything like that before. She was aghast and just can't describe the feeling of terror that she had all over her because she recognized that he was purple. Well, the pathologist testified earlier in the trial that Mr. Torres died as a result of postinial asphyxia, and the death was ruled a homicide. Now, prosecutors argue that Ms. Boone showed no regard for Mr. Torres' life, and her attorneys have claimed that she was the victim of the battered spouse syndrome, so therefore everything's okay. Now, under cross-examination, prosecutors pushed Ms. Boone pretty hard on her testimony, particularly in regard to a neighbor who said she heard a loud thud and that the neighbor heard a loud thud the night of the murder. Now, the prosecutors then suggested that Ms. Boone pushed the suitcase down the stairs, and she was questioned as to why she felt it necessary to teach him a lesson while in the case. She said that that was no lesson to be learned, but that she wanted him to know how she felt from the abuse that he had given to her. Anyway, the prosecutor asked the question, did you do anything to help him escape from the predicament that you zipped him up in? And Ms. Boone replied, no. Didn't go well for Miss Boone. Obviously, we couldn't see the jury, just the way that she was looking ahead. Miss Boone was looking ahead. I got the feeling she wasn't making good eye contact with those jurors because they were bonding with her and saying, oh my God, thank God you lived and survived this horrible experience. Really? A suitcase? Drunken games? Are you kidding me? This is what you refer to as felony stupid, ladies and gentlemen. This woman probably is going to go to prison when the jury convicts her of something. We'll wait to see what they decide. But 8 attorneys, now on her 9th attorney, and 4 years for that testimony. Are you kidding me? She should have taken that 8-year deal that was offered. Hell, she'd be done by now. She's already served 4 years in custody. Next, a Georgia shooter says not guilty. The Appalachia High School shooting suspect, remember that kid, Colt Gray, pled not guilty and wants a jury trial. That's right, the 14-year-old accused of killing 4 and wounding 9 others during the mass shooting at a Georgia high school back on September 4th of this year, waived an arraignment hearing that was scheduled to take place on November 21st. So therefore, he won't have to show up on November 21st. Anyway, a grand jury indicted Gray on a total of 55 counts as an adult, including murder and the deaths of 4 people, and 25 counts of aggravated assault at the high school. Now, the grand jurors indicted his father as well, Colin Gray, on 29 counts, including 2 counts of second-degree murder and 2 counts of involuntary manslaughter, and both also faced multiple counts of cruelty to children. Now, Colin Gray, the father, was arrested and charged with allegedly purchasing the firearm used in the shooting and giving it to Colt for a Christmas gift. Now, the September 4th shooting resulted in a teacher, Richard Aspinall, and Christina Irmi, and students Mason Schemerhorn and Kristen Angulo, both 14, and another teacher, and 8 more students were wounded. 7 of them were hit by gunfire. Now, Colin Gray has not entered a plea as of today, and remains scheduled for his arraignment, scheduled for November 21st. Now, Colt Gray faces a maximum penalty of life in prison without the possibility of parole if he is in fact convicted, which he will be. Next, the Menendez brothers may learn their fate. That's right. The Los Angeles County District Attorney George Gascon says that he is going to make a decision on whether to recommend resentencing for Eric and Lyle Menendez in a matter of days, and that the brothers are not a danger to society. Gascon says that based upon everything that he knows, he doesn't believe that they are a danger. Quite frankly, said they probably haven't been for a very long time, and if they ever were, I think it's not like they're going to go around killing people or robbing people on the street. Now, Gascon made those statements in an interview on October 21st, and he says that he plans to make a decision about the resentencing by the end of the week, after he's discussed the case with his office habeas people, as well as their resentencing units. Now, he says that he's going to be listening not only to the briefings, but recommendations from both teams. And he says that that's going to play a role because they're not just sort of an agnostic presenter. They're going to be presenting what they think should be the appropriate outcome. And he expects that he'll be saying no relief. One will be saying, yes, provide relief. And then he's going to have to make the decision of which way to go. Now, Gascon can only issue a recommendation on resentencing, and a judge would have to make that final decision as to whether to basically allow somebody to withdraw their plea or vacate the conviction, maybe allow them to plead to something else, and then basically be given credit for time served. So Eric and Lyle Menendez, 53 and 56 respectively, are currently serving sentences of life in prison without parole after being convicted of the first-degree murders of their parents, Jose and Kitty Menendez. Now, George Gascon says that some of his team members don't believe the brothers were molested by Jose, the father, but Gascon believes that the kids were, in fact, molested. They're not kids anymore, they're grown men, but when they were kids, they were molested. Anyway, Gascon went on to say there are some people in his office that believe there is no evidence of molestation. I don't agree with that, but that's certainly the position that some people in his office take, and they believe they should stay in prison for the rest of their lives. He says there's other people in his office that believe that there are probably some evidence of molestation, and there is additional evidence of rehabilitation. So he is going to have to decide the issue. In fact, they say that they have been rehabilitated, as is being alleged, and we're reviewing all of that information as they've been in prison for now some 35 years. Gascon says 35 years is a long time to be in prison, especially when you look at the circumstances behind the case. It seems to me that there had been a place for redemption or rehabilitation at some point. But again, whether they believe they should or shouldn't be in prison the rest of their life, it's not necessarily what he is going to alter his final decision. His decision is going to be based upon evaluating the law, and we'll have to wait and see what the recommendation is. I think it's going to be a recommendation of get out of jail free card for the Menendez brothers. You know, the funny thing is when you do a lot of cases that involve violence and people that are dead, everybody has mitigation. Everybody's got a sad story, but they don't let our people out, so to speak, unless, you know, there's some celebrity, cause celeb situation where these people, the bandwagon gets on the fact that they were abused. Well, lots of people were abused. I got lots of clients that were abused. I got clients that went through a lot of stuff, worse than the Menendez brothers, and they're probably never going to see any relief whatsoever, assuming everything they say is true and correct. Doesn't give you a license to kill. Next, another Mother of the Year contestant. We haven't had one of these in a while. A mother from Ohio faces some prison time for leaving her twin daughters who have special needs in the care of a 10-year-old while she flew to Florida for her friend's liposuction surgery. Yep, you heard it, ladies and gentlemen. Kids, take care of yourself. I got to go help a friend get some liposuction. Please meet Dominique Knowles. Now, she is accused of leaving her 3 children home alone without a phone while she was gone for 3 days. Now, police allege that Miss Knoll used a laptop to check in on the kids via FaceTime while occasionally monitoring their activity through some security cameras. On one night, apparently, they were able to tell that the kids ate some food through an Uber order, and that food was left outside. Now, prosecutors also allege that the mom's young girls made it clear that she wasn't really checking in as she traveled with a pal. The cops said remote work is one thing, remote mom, well, that's another, the police said. Anyway, Ms. Knowles was ultimately found guilty of child endangerment earlier this month, and she told officers on the body cam footage, "My kids are allowed to be home by themselves." The cops responded, "Not when you have 2 special needs kids," the officer told her. But Ms. Knowles took her 8-month-old son on the trip. There's some mitigation, right? Anyway, it was the 10-year-old's teacher who asked police to perform a welfare check on the children after a worrying conversation with the child. Apparently, on a phone call to the police, the teacher said the 10-year-old kind of reported to her teacher that she talked to her mom on camera last night and that the mom ordered them some Uber Eats. Knowles never told the children's grandmother, apparently, who lived nearby, that she was leaving and that the kids were home alone while she was out of state. Police say what's worse is that mom lied to her own mom because there were adults who were willing and able to watch the children. Anyway, when the mom was confronted with that, she changed her whole story and said something about having to be in Miami because her friend needed liposuction surgery. Anyway, Miss Knowles is scheduled to be sentenced today and could get up to 6 months in prison. Prison, maybe some parenting classes, responsibility. I don't know, ladies and gentlemen. There's just some things you just literally want to scratch your head and think, how did we get here? Next, this day in legal history. On the evening of October 23rd, 1973, following the Saturday Night Massacre that occurred on October 20th, there was a huge public outcry and legal turmoil intensified for President Nixon. That's right, the massacre involved the firing of Special Prosecutor Archibald Cox and the resignation of Attorney General Elliot Richardson and Deputy Attorney General William Ruckelshaus during the Watergate scandal. This led to increased pressure on President Nixon, eventually resulting in the appointment of a new special prosecutor and further legal consequences in the Watergate investigation. And then on October 23rd, 1987, the United States Senate rejected the Supreme Court nomination of Robert H. Bork by a vote of 58-42, which was affectionately now known as being borked, because it really didn't happen that often before that, ladies and gentlemen. Next, our dumb criminal of the day. Take a look at this video. I don't know how else to do this. You just have to watch it and really, once again, scratch your head and say, is this where we have come? No accountability whatsoever. Anyway, in this particular video, you can see this unidentified driver stopped from driving the wrong way down the street, and then the cop smells an odor of an unknown alcoholic beverage, which then leads to a DUI stop. She can't do anything because of her anxiety. Take a look at this. Is this the world we live in?
What's going on?
Nothing.
Why are you driving in the wrong way of traffic?
No, I just got changed around. I just moved here like 2 months ago.
Okay.
I just got changed around.
Okay. Do you understand what's going on, though?
Yes.
You're going into oncoming traffic.
I know, and I just decided that it was better just to turn around really quick.
Okay.
But I'm sorry. I just have like really bad social anxiety and stuff.
I get you.
I don't want to step out whenever you're asking for stuff.
Okay. Well, we're past that. So just go ahead and step out.
As an Indigenous person.
Right back here, please. Miss Perry?
Well, I'm non-binary, so.
Okay. What do you go by?
It's Kai.
How can I refer to you tonight? Kai?
Kai.
Okay. Hey, I'm smelling alcohol.
I know.
How much have you consumed tonight?
Like probably 3 drinks.
I need to run you through some tests right now. Stand facing me, please.
But I just want you to know that I also have very bad social anxiety.
You and me both.
Okay.
Okay? Any recent head trauma, traumatic brain injuries, anything I need to know about?
Mental, yes.
Focus on my finger, please.
I am. You're just like trying to intimidate me.
I don't know how I'm trying to do that. This is the test.
As you know, as an Indigenous person, and there's a bunch of going around. I'm sorry, but it's just for me to be on my toes.
I get you.
Can you remember that I told you that I'm non-binary?
Yeah, I'll try my hardest. I'll refer to you as Kai, right?
Yes.
Perfect. I need to know if you have any injuries or anything that would prevent you from doing a standard walk or turn tonight.
Mental health.
Any physical injuries?
Mental, yeah. But no, I'm just saying.
Okay.
Mental, PTSD, depression, anxiety.
I get you.
What else do you want?
Now with your right foot, place it in front of your left in a heel-to-toe touching manner with your arms by your side, just like this, ma'am.
Can you not call me ma'am, please?
I'm trying my hardest.
Okay, well,
Okay.
it means a lot to me.
I'm trying my
I
hardest.
don't feel like a man, so
Okay.
it's kind of triggering.
Right foot in front of your left. Nope, go back.
I'm sorry, but the whole man thing, just like,
I apologize. Let's see if we can move forward from it. You have 0 questions?
no, but I just want to tell you that I suffer from really bad anxiety, especially with generational trauma and PTSD around white people and cops. Like, it's just,
I'm going to speak with you right over here, okay?
no.
Yes, ma'am. Go ahead and place your hands behind your back.
Don't, dude.
Don't make it hard.
Please.
Don't make it hard.
No,
No. You're going to get a resistance.
Dude,
You're going to get a
I
resistance.
don't.
Don't resist.
Don't.
Listen to me. Don't resist.
Don't. You're being
Come
a
here.
white man and
Come here.
don't. I fall in all of your shit. Like, as an indigenous person, like, you guys. You guys are scaring me.
There's nothing to be afraid of.
Yes, there is. It's called.
The police officer should get an award for his professionalism and the fact that he was so courteous throughout this encounter. Anyway, that's all we have for you today, ladies and gentlemen. Thanks for joining us. Have a wonderful day. We'll see you next time. And remember, the Constitution matters.